All right. What's up, guys? Sorry about that. We're back. We're live. Share the stream. Hopefully, you're hitting refresh and you're jumping back in here. Um, yeah, this is the beginning of the end. Beginning of the end. And yeah. So this is where we're at right now. We are on a courtroom break while we wait for uh, the they're just doing their last stretch before they jump into Darrell Brooks. So share the stream out, you guys, if you're coming back in. I know we had about 400 people in there, but I know. But we just started our new live, and we are back in. Not a big deal. Just had to refresh it. So, but again, I'd rather do that to us while we have a break right now, which we are on one, as opposed to doing that when we're in the middle of hearing him what he has to say, hearing what he has to say. So Darrell Brooks will be coming back in in just a few moments, in just a few minutes here, and he will be uh, he'll be giving his final arguments. So that should be, I'm sure, very interesting because who knows what this guy has to say that he thinks is going to sway this jury in any way. I mean, he was objecting to even the prosecution's closing arguments, which, I mean, what? How do you object to that? So this is, you guys, if you don't recall, this was we'll pull it back a little bit here, let you guys watch the tail end of Darrell Brooks in his closing arguments. Uh, and we're going to do this one. So again, I know people were nervous about it, being missing out on the uh, ba, 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 ba. All right. Well, yeah, I'm going to pull this in here, and we're going to go ahead and I'm going to show you guys we'll be back in just a minute with the closing arguments. But yeah, make sure to get back in here. We had like 400 people in, so we're about 180 short of folks that were in here. So I don't know where everyone went, but wherever you went, you don't hear this. But I'm sending out a cosmic message to come back. This is Darrell Brooks. His opening. This is his opening. Yeah, his opening statements when he was giving his heartfelt uh, plea to the people. You know what I mean? This is prior to. Uh,
Words like demon. Words like monster. I know a lot of the time I've been before you see me with this mask on. I've had my reasons for that.
So what I'm going to do for you guys here is do a side by side, so we can see the courtroom and we can watch his opening. These are his opening statements, mind you. So anyone who's watching, I know people ask a lot, but hear what I'm saying. These are opening statements from when he first opened. But so this is a way we're not going to be able to. You won't miss anything. I want you guys to make sure that you're not having to worry about it. So on the right is where we're at in the live, and on the left is the opening statements that he gave just a handful of days ago.
But I feel now is the time to. It's important that you see me for who I am. No mask. For who I am. think this is the moment for that.
And like I said, the jury or the court will be back in just a few minutes for the final closing arguments by Darrell Brooks. Share the stream, guys. Please share the stream. These are his opening statements. So we're doing a contrast and compare between how he introduced himself to the jury and how he's going out.
Your eyes and ears remain as open as possible. Understand that you alone decide.
Good question.
This case, this matter. The power is in your hands. All of you. To determine for yourselves what truth is. Thank you.
Thank you, sir.
So that was, and then he was so shook up that they had to take some time to collect himself because he was just so shook.
And do we have their writing materials available?
The
Thank you.
polar opposites of the guy who's
Mr. Brooks,
realizing
you ready to
he's
call
cooked.
your first, would be your second witness, actually.
At one point when he had his defense attorney, he was crying when he first came into
You need a
court.
minute?
And she reached over and patted him, and then she like pulled her hand back, like, "Oh wait, yeah, I can't do that. Can't do that." No love lost for this guy. None. This guy right here he's putting it on. You know what I mean? Great. He could have hit his brakes at any point in time. He could have stopped his car at any point in time. He could have pled guilty at any point in time. He could have said, "I'm sorry for what I've done. Please, God, give me the strength to take the full weight of the burden of responsibility for my crimes, my actions. Allow me to
I'm
be
going to take a
leveraged.
short break. I'll rise for the jury, please.
All of the penalty that they could possibly give me in some way, shape, or form, you know, give me the strength, blah, 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 you know, to be able to carry, you know, the weight of what I've done." And he's not there yet. He's not there. He's not there. And he'll never probably ever be there. He's going to go ahead and feel like for forever, probably, that in some way, shape, or form, you know, he's been wrong. He got a bad shake at trial. He got a whatever, fill in the blanks. But for this guy, for whatever reason, in his addled brain, has got himself convinced that just like this. Okay. And I've used this metaphor a couple times. He feels, and this is what I've been observing, that if he gets an acquittal, he won't. But if he gets an acquittal, if he gets a mistrial, if an appeal goes through, all of that will absolve him. In that book that he's carrying, the book, you know, it's not a book, Judge, it's the book. I can't argue with that. But then he goes ahead and laughs at her. You know what I mean? The dog doesn't even like him, I'll tell you right now. But with that, so I think he feels that God will like absolve him. Like if the courts if I can skate through the court system, then maybe somehow I'm not guilty of what I've done. Which is like just what he said in his video, this rant that he went on when he was talking about how he did Erica Patterson when she was 15, when he raped her as a child and got her pregnant. He was like, all of a sudden we have a falling out, and the chick, you know, and he said the bitch, he's like, yeah, all of a sudden I'm a pedophile because we have a falling out. She want to go tell the police, fill in the blanks, press charges. He goes to prison for 11 months for statutory rape of a minor. His head works. I was only guilty of statutory rape of a minor when I got brought up on charges for raping a minor. What he doesn't understand is you became a pedophile when you raped a kid. That's when it happened, not after the fact. And like I've said before, when you steal a car, you're a car thief. You're not a car thief once you get caught and tried for grand theft auto. You know what I mean? Like, once you do the act, that's what you do. That's what you are. You know what I mean? Not if you get caught doing it. So in this, I think in his brain, I think somewhere in there, he feels that if he can skate through this, maybe he'll get absolution. You know what I mean? And honestly, maybe he doesn't care. I don't know his real. Nobody know. I don't think anybody knows who Darrell Brooks really is. That's his business, as he's been saying. That's what the business is of Darrell Brooks, is just being whatever he needs to be to skate through the system. He's done it for his entire life since he was 17. You guys, he should have done over 30 years since he was 17. He did less than 3 years, about 3 years in county and prison, including the charge for statutory rape of a minor. There's nothing about this guy that is repentant. There's nothing about him that feels any kind of accountability, because he hasn't had to. He's been able to just wave it off, and laugh in the face of the courts. And in all fairness, to be real about it, the courts have done a phenomenal job of allowing it to happen. And it's sad. And I'm not saying that this is just me being very blunt about the fact that courts sometimes, well, they mess up too, and but when you've messed up as many times as they have with him, at some point you have to say, all right, man, like we dropped the ball, so hopefully the judge has a chance in this case to say, hey, you know what, this is it. This is the redemption for all the things that he didn't get tried for, all the things he didn't have to go and pay the penalty for. Today's the day. So, and I want to bring in our lawyer friend, if she's available. Not right now, obviously, because we have closing arguments. We had a poll going on Facebook. I'm not sure if it's still up. Go over and check it out at CJTV Media LLC on Facebook. If we think he's even going to do a final argument, or he's going to waive that right, or if we think that he's going to start his final argument and get shut down by the judge, and because of what he's going to be doing, and or if he's going to be able to get through it. Yeah.
For the record,
he told me that. He told the judge. She told me he pled guilty
in the main courtroom prior to
the charge of
opening following the break. I did
statutory
invite
rape.
him back into the courtroom.
So he's been invited back.
He is here. I trust you are ready with your closing argument, sir.
He's back in the courtroom, guys.
Subject matter jurisdiction.
Oh, sweet Lord.
That request is denied.
How long is he going to make it?
Just for the record, I was
comments, guys.
addressing it for both courtrooms here in courtroom number, I think it's 20.
He represents
Mr.
both
Brooks,
courtrooms.
I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record.
Share the stream, y'all. This is it. This is what we've been waiting for, is him to finally say what he wants to say, what he hopes the jury.
Are you asking for another copy of that, sir?
Yeah, because I don't have it.
Dance.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Please share the stream,
Is
though,
it
guys.
proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out for the record. The written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Okay, guys.
Please be prepared with
In
your
comments,
closing argument.
how long is he going to last in the courtroom before he gets booted over to his,
Or is
what I
it a
call
tacit agreement that you don't
his,
have to answer any questions as a public servant?
All right.
his box court,
So that is a tacit agreement.
or his fort room, if you will. 0 seconds,
To reflect
6
the
seconds,
jury's
0.
coming out.
Yeah. So yeah, when the trial wraps here, you guys, we are going to jump in. I'm going to bring
Thank you,
on
everyone. Please be seated.
an attorney friend of mine again, and we're going to talk a little bit about what we've seen today, next steps,
Go
where
ahead,
we're going
sir.
from this. So
You may
we'll see
begin
where
your
this goes.
closing
Darrell's
I'm not ready
box
to
fort.
begin
Yeah.
closing arguments.
I'm not ready to give closing arguments.
So this is your opportunity to provide
This
your
is it.
closing argument
Share the stream.
to the
This is
jury.
it.
Please start.
All he
I
gets.
have started the timer
Last opportunity.
of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth.
She's warned him.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
73.
Did you inform
They will
the
be
jury-
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that.
That's one thing she
And
warned
I'm
me about.
advising you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
if
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
How long was it? How long was it? Somebody's got to go back and check. Oh man, I'll do it for us real quick. The jury's being he isn't kicked out yet, but the jury's being moved to the other court. Sorry, I didn't mean to yell into the mic, guys. The jury's being moved into the other courtroom or moved out, and so that's I'm curious how long he made it. Actually, we'll let one of the mods would you chime
Mr.
in?
Brooks, you do not have
Let me
the
know how
right
long he made it before the jury was
to
removed.
request jury nullification
Yeah.
directly from this jury. I direct your attention
It's one of the two. It's
to
one of
the
the two.
Bajurkas case, BJERKASS. That's
Didn't say
State
Waukesha,
versus
obviously.
163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury, twice while you were in the other courtroom. I was able to mute half of what you said the second time. And then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice. So you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in open court?
I have not made such a determination as of yet, but you can forfeit your constitutional rights
under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court of
Allen.
Wisconsin referenced both that
He
decision
cannot make it.
when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
She gave him 1
Mr.
hour.
Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you are
not trying
going
to
to
give-
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
Exactly
I'm
what you're
asked,
saying.
that's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the, you just said on the record that they have the power for,
Sir, I direct your
you
attention.
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
She
not
should just
telling
let
you
him
no
tell
such
him.
thing.
It
It makes no
Disregard
difference. You know what I mean?
My directive to you to not raise the issue of jury nullification during your closing argument.
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
they have the power.
No party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor.
In
I just
that
want them to be
case,
informed. I just want them merely to be informed.
You can
That's
call
it.
it informing.
It's good of him
making
to
them
want to
aware.
inform the jury
Yeah,
through his legal
Whether-
they
expertise.
should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can
an
I not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have,
have?
sir.
He is pulling
I'm
every
not
little
giving
arrow
a
out of
new
his little
jury
quiver that he
instruction.
can. This is the very last one.
That is
That's not
because
what I'm
there is
arguing.
No
Counted
jury
jury
instruction for jury nullification.
Yeah,
I'm not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Yeah, exactly.
That's not against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They
Got
are
the
not
cop
to
look
be
right there.
instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
the record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's times 2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
Or
how
you've
did
interrupted me
I have why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end
Brooks.
of last night before you called recess.
I'm not going to debate
We had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we go with
can
this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify.
Would
He
you
said,
like?
"Here
You
we
would
go
like?
with
But then I
will
said-
read this to you, sir. The part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom,
At some point,
but that is
your final warning is your
oftentimes
final
what I
warning.
need to do in order for this
That's it.
court to make a full record
That's it.
without you interrupting me. But you need to be fully aware
He is fully
that
aware.
you may
100%.
not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No,
because
you can't change the law, Your Honor. You can't change the law. That's
I'm not
practicing law
changing
from
the
the
law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are. If you're changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time did
telling
you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkas, 163 Wisconsin 2nd at
Well,
549. That's a Court of Appeals
cases,
case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility,
If I never heard
and
jury
to ensure
nullification
that
again in
this
my life,
jury
I'll be too soon.
is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How's that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
That
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
The fact that you're making it up, you can
Sir,
say
I
that an
intend to bring this jury out and give
intergalactic
you
cosmic being
an
told you the
opportunity
rules of law, but that
to
doesn't make it true.
present
you
a
know?
closing argument.
Yeah,
If
but
you
you're
violate,
also- you're
please let
also-
me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
Why does she let him keep
The
talking
circumstances
over
require
and
that
over
I
and over her?
implement this rule, sir, given your
The
some
stubborn
point-
defiance on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to
The
bring the
Bajirkas
jury
decision.
And I'm
out.
going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to
You
present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
Then
upon
I make a
how I've
oral
outlined that to
motion
date.
for
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
You need Jesus.
May I ask the court to consider perhaps an alternative? And I
Just
fully
saying.
respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to
say the
allow
least.
this to allow Mr. Brooks to
6
try
people,
and
Chad
proceed.
Alvarez. He killed
But
6
I think we
people
should
and injured
try
61
that or
others.
something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
6 counts of first-degree intentional
Certainly
homicide,
willing
61
to try
counts of
that.
recklessly endangering safety, 6 counts of hit and run involving death, 2 counts of
About all we can
jumping
come
a
up with,
bail,
Your Honor.
2 counts of
I'm
battery.
certainly willing to try it in this courtroom, and then
All over
if he
900 plus
disregards
years
that,
and 6
to
life
excuse the
sentences.
jury, and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
I love that he's sitting there having to listen to
Your
them
Honor,
just
I
talk
object
about
to
what an asshat he is. Of course you object to it.
Your objection is noted for
I
the
like his
record. That will be the
lapels
course
are
of action that this
doing
court
this thing.
takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling?
How long will he last with a jury in the room?
Tacit agreement that
How
you don't
long?
have to answer my objection, Your Honor.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Denied.
Under
The jury
based
is
on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact?
How long, people? How long do you think it's going to last? Because so far, here we go.
Of their power. They deserve to know.
Here we go. Jury nullification. Swear to God. Never again. I mean, would I ever want to hear the term? 5 minutes, 7 minutes. All rise. Let's see how long he can handle himself before he gets thrown over into the Darrell Brooks box fort, or we like to call his the fort room.
Thank you, everyone. Please be seated.
5 seconds, 2 seconds. All right.
Go ahead, Mr. Brooks, your closing argument, please.
They've been in for 5 seconds. Here we go.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
Probably should have.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart.
No, you didn't.
In my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause.
Did the same routine last time.
it's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year.
There's so much I
For the
want to say,
families,
guys.
mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone
What?
while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to.
Here we go.
And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model.
He's about to say it drove
fact
itself.
recall.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
For argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to.
The car did it. This mother.
Weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's
completely
information,
inaccurate,
it's
Your Honor.
There's an
information.
objection. Hold on.
Strike-
Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's complete.
Information.
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children.
One of which was born out of the rape
Talking
of a
about
15-year-old.
someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget.
Neither will a
Yet they say
15-year-old little girl.
disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does?
When you do something, that's typically the response of what your brain was thinking to do. I'm going to
Yeah, it
move my
makes
hand.
references to
I'm going to push down the gas and
lots of
drive
no
through a
one
crowd of people.
being injured.
Guess what? Your
But
body
then says
responded.
it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill. And it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle?
What if you were possessed by the ghost of someone who didn't know how to stop the vehicle?
Because of that fact, what if the driver may have panicked?
There's a ghost in my body. What do I do? It's making me do things I don't want to do.
Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
Whether you were rage filled or not, you did it, and you could have avoided doing it by not doing it, but you did it and kept doing it, and then these people died.
Exhibit 17. You don't see anyone struck in that vehicle.
But he didn't do it, guys. Remember,
On that
he's not
exhibit,
Darrell
you
Brooks.
don't see anyone struck.
So no one got hit.
Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people.
He wouldn't even look at the jury, like barely ever, because he already knows it.
Reference was made to
What they're going to be
this
looking back at him with.
The damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost on the alleged defendant.
The prosecution's heartless for not thinking about it.
And the people have been disregarded.
That's right. We should have been just talking about that and not sentencing you to murder.
Makes me wonder, does the DA even care about those people?
Oh my. Come on, guys. Go ahead and emoji in here what your thoughts are on what you're hearing right now. Please give me some comments about what you think about what you're hearing right now.
Prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss.
Much like the families weren't going to be able to hold their loved ones that you murdered. Like the 8-year-old little boy you killed.
Sorry, something's not.
Everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How?
This is crazy. Like, this is blowing my mind right now. How could it you did it. That's how it happened.
The hardest hardest questions you can ask is those that don't have an answer.
There is an answer. You did it by driving through the parade.
No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't.
You deny doing it altogether. You even deny that you're the person who did it. What, did you mean to do it? We don't care. You did it.
As a matter of fact, it never even crossed my mind to even attempt to ask myself that because I know it wasn't.
Asking myself that, are we? There's one vantage point. You driving your car through
And
the
I know
parade.
sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books.
So you know it's from the heart.
Everything you've heard, opening statements, everything you're hearing now is from right here.
My little teeny chest. Who cares? I mean,
You have the decision. You and you alone, all of you, you have the decision.
the first time he's looked at the jury, he said the same thing in his opening statements.
I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you.
He practiced that in the mirror. He's like, and then I'll look at the jury and say this. Don't let him take that away from you. Long story.
I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure.
No verdict today.
I pray that the right decision is made. The right decision. It's almost like that message.
Don't quote it.
Well, not message, but that writing. When we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
No, that's not what that means at all. It means it's magnified or it's not magnified. That's what that means. To closer or not close.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Because he didn't do it, right?
And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included.
Did he just basically say he was carrying out God's will by driving to the parade? That was God's will that it happened, and he was an instrument of God?
Wow. No matter how much sometimes we want to question, you have to have faith.
You're going to be living a George Michael song, so I guess faith is appropriate, yeah.
Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right.
That's TED Talks work right there. You say it twice, it makes it, more substantial.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power.
They're your theatrics. Your smoke and mirrors.
Each and every one of you has a decision. Who's right?
He's acting like a victim right now.
Make the right decision.
Someone said earlier, like, this is a victims panel. In sentencing, this is what hopefully the victims will have a chance to be able to say about you. You did this to them, to all of these people, and to all their families, and dozens of other people. You killed these 6 people. You have no remorse. I don't think we're not
to think about.
Yeah, just convict on all counts. Cook this fool.
My younger kids getting older and at some point having to explain everything to them.
You raped a child.
Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much.
Yeah. Like the one that you were using as a prostitute in Las Vegas when she was 15.
I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you? I haven't read the rest of that letter yet. rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
It will be when you get found guilty of 6 counts of murder.
So before I close my statements, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. just like this tissue is in my hand. This is everything. You have everything. Be at peace with what you decide.
I think everyone will sleep pretty soundly after convicting you.
Had no regrets.
Nope.
Don't let this decision weigh on you after it's over.
Pretty sure it won't.
Hopefully we got a long lot of living ahead of us,
In prison.
Lord willing. Don't look back and kick yourself in the behind.
They won't. Speaking of behinds, though,
It's been about 3 weeks with you. And took a lot of courage and a lot of guts to pause your life for this.
well, it's kind of the law, actually, but I'm sure it's just more terribly uncomfortable
Putting things on hold
to watch you.
to basically stop your life. You should be commended for being able to sit up here with this amount of pressure.
And look at the guy who stopped these lives. Yes.
I want you guys to know that's not lost on me. I'm sure it's a lot.
Nope, not really. Yeah, he compared himself to tissue.
You all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
None of us wanted to be sitting in this position. We wish it never happened, but you did it, and so we're here
And you
because
guys had the guts to do it.
Yeah.
Thank you for that. Thank you for taking pretty much a month and setting it to the side for this.
I would love a chance to convict you of murder. I mean, I've been sitting here all the time too.
Proper, but you guys deserve a round of applause if you could get one.
Let's go ahead and take a minute and do that, actually, because they do deserve it. Having to sit in and look at this asshat every day. So all of you do, really, for having to sit in and look at this asshat every
Thank
day.
you guys sincerely.
Raging hemorrhoid.
And I know, and I have faith and I trust that you guys know what's right.
Yeah, absolutely. You're the only one that doesn't get it.
Ladies and gentlemen, I don't think it's fair to just say guys.
That's so woke of you. You're so proper. Good job, Darrell. You've really grown a lot in jail.
I believe in your heart you know what's right.
We all do. You're the only one that's confused. You still have to go back to your jail cell. You're going to go to prison. That was it. All right, good deal. Wow. Oh. Just want to wrap my arms around him and hug him and just keep hugging him. You know? Whew. Really, really compelling stuff there, Darrell. Really compelling stuff. Wow. If they're going to break, I am thrilled at an opportunity to say some of the things that I've had to
Have a seat, please.
bite back
Attorney
since.
Apparai.
He said it was God's will.
Closings, you have 13:28 left.
He also blamed the DA for not focusing on the victims. Shame on them. They've been focusing on their murderers. Shame on them. What the actual is going on with this? Oh, here it goes. These terrible human beings.
Professes to speak to you from his heart. He plays on your sympathy.
Of course, I'm not
Talks
serious.
about his children. talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son, never once acknowledges the Sorenson family, the Owen family, the Durand family, the Hospel family, the Kulich family, Sparks family. Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulich fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count 4. Count 4. One reading. We, the jury, find the defendant, Darrell E.
So they're going to
Brooks,
go through this
not
reading for a
guilty of
little bit here.
first-degree intentional homicide as charged in count 4 of the
It's the
information.
last of the jury
Another
direction.
reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide
To be
while
clear,
using
though,
a dangerous weapon?
It won't be
One
tonight. I
reading,
don't
we,
think
the
there's any
jury,
way.
find the defendant, Darrell E. Brooks,
But they'll
not
come back with a
guilty
verdict
of
tonight. Maybe
first-degree
tomorrow.
intentional homicide as charged in count 5 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 6. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 6 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 7. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 7 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 8. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 8 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 9. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 9 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 10. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 10 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 11. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 11 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 12, one reading. We, the jury,
Well,
find
this
the
is day
defendant,
14
Darrell E.
of the
Brooks,
trial.
not guilty of first degree recklessly endangering safety as charged in
Part
count
2 of
12
the day.
information.
Today we've been here
Another
for
reading. We, the jury, find the
9
defendant,
hours, 45
Darrell E.
minutes.
Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 13 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 14, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 14 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 15, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 15 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 16, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 16 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 17, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 17 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 18, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 18 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information.
Thank you, Danielle.
If you find the defendant guilty of first degree recklessly endangering
54
safety,
more to go.
answer the following question, yes or no.
I'll tell you guys what,
Did the
man.
defendant
I'm really
commit
tempted
first degree
to
recklessly endangering safety while using a dangerous weapon? Count 19, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
I mean, in
of
the
first-degree
comments here, do you guys want me to
recklessly
just keep
endangering
letting it roll
safety as charged in count
as
19
we're
of
listening
the
to this?
information.
Or
Another
would you like me to
reading.
bring on
We, the jury,
an
find the
attorney
defendant,
right now? We
Darrell
could
E.
go ahead
Brooks,
and talk
guilty
about
of first-degree
what's going on,
recklessly
ask some
endangering
questions.
safety as charged in count
and
19
kind of
of the
mute out the
information.
court
If you
because,
find
in
the
all fairness,
defendant
this
guilty of
is
first-degree recklessly
got
endangering
potential to go
safety,
on for a little while.
answer the following question, yes or no.
Let me know.
Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 20, one reading. We, the jury, find the defendant,
Bring on the
Darrell E.
attorney.
Brooks, not
Yeah, I
guilty
think
of
honestly, I would
first-degree
much rather.
recklessly endangering safety as charged in count 20 of the information.
Yeah, So
Another
is he or
reading,
isn't
the
he?
jury
Please
find the
catch me up, my
defendant,
friends.
Darrell E.
We're
Brooks,
not there yet.
guilty
Is the judge
of
allowed to
first
say
degree
yada, yada,
reckless
yada? Yeah, I
endangering
wish the judge
safety
could
as
say,
charged
hey,
in count 20 of the
because they've
information.
got 61
If you
counts,
find
which
the
is like
defendant guilty of
122,
first degree recklessly
obviously,
endangering safety,
recklessly,
answer the
or
following question, yes or no.
recklessly
Did the
endangering
defendant
safety.
commit first degree recklessly endangering safety while using a dangerous weapon? Count 21. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 21 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information. If you
Yeah,
find the
I'm going to
defendant
go ahead
guilty of
and
first degree recklessly
bring on,
endangering
I'm
safety,
going to try to
answer
bring
the
in
following
my,
question, yes or no.
the attorney
Did
out
the
of
defendant
Hawaii,
commit
or out of,
first degree
sorry, out
recklessly
of,
endangering safety while using a dangerous weapon? Count 22, one
out of
reading, we
Houston.
the jury find the defendant, Darrell E. Brooks,
And
not guilty of first degree recklessly endangering safety as charged in
because
count
this is
22
painful
of the
to listen
information.
to. It'll
Another
be
reading, we
going
the
on for a
jury
little while.
find the
And,
defendant, Darrell E. Brooks, guilty of first degree recklessly
we'll chime in
endangering
with it, but
safety as charged in count 22 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree
I'll
recklessly
keep a side by
endangering
side
safety
going.
while using a dangerous weapon? Count 23. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 23 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 23 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 24. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 24 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 24 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 25. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 25 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 26. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 27. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 27 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant
yeah,
commit
guys,
first
collectively
degree
he's looking at
recklessly
900
endangering safety
years
while using a dangerous weapon?
plus 6
Count
life
28.
sentences. 900,
One reading,
over
we
900
the jury
years.
find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 29, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 29 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 30, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree.
All right, Luai, are you there?
I'm here. Can you hear me?
I can, yeah. So let me explain to everybody what we're doing, and then we'll kind of better explain what we have going here so that people don't freak out. So you guys, just so everybody's aware of what's happening right now, I've turned down the volume on the courtroom. They're going to be reading. I'll have it just barely audible underneath us right here. They've got 70 plus counts that they have to read guilty, not guilty, basically verdicts for. They have to read this to the jury, and there's no death penalties now. The only thing they're looking for is life. So right now, and Loya, I'm saying your name right. All right, am I?
It's pretty good. Yeah, you call me Lou. It's easier.
Lou? All right. I'm not even going to attempt your last name. I've never been able to. It's just not happening. But tell us who you are, where you're from, and what it is that you do.
Lou Claycow. I'm an attorney in Houston. I have worked for the federal court system. I've worked in private practice. I've done government work. I've done a little bit of everything, but the majority of what I do is litigation.
Okay. Now, you've been following the case. We talked a little bit earlier. I know you had a meeting to jump into, so thank you for hopping in earlier.
Sure.
I know a lot of people they kind of got left with questions in their hands. So we're going to try to walk through some of that and kind of get an idea of what our next steps are here. So from today, moving forward, what's going to happen today? What are we looking at here?
So before this point, the jury wasn't supposed to talk about the case. Everyone was supposed to just listen. Their notes had to be turned in every day. And this is go day, right? So now they're able to finally start talking to each other about the case. They'll start deliberations tomorrow. I really don't think they'll be deliberating at all today. It's too late. They'll begin deliberations, and then everything you just heard the judge read, they're going to have to decide, even if he's guilty, which I'm sure you've seen the polls online, like 96+% of people, are finding him guilty on everything. They want, all of these things charged. There's nuances here. So, what was his intent? You saw him talking about intent a lot. I didn't intend to do this damage. I didn't intend for people to get hurt. I didn't have premeditation. The jury will have to go through every single charge one by one. And the judge read go ahead.
So I'm not sure if they're done reading. I don't think they're done reading charges yet.
They might not be.
Taking a standing break here for the mid-range there. But first question. What's that?
For every charge that they have, there are a lot of variations.
Sure.
And they smart of the prosecution to have charged.
33. One reading. We, the jury.
They're only at count 33. They've got like 70 to go through, guys. So we're not missing anything right now. And Lou, it looks like you're kind of in and out on us here.
Yeah, give me one.
So like I said, we've let me see here. So like I said, we're going to be
Is that connection better?
Well, I can see you now. Yeah,
good.
So that's saying something.
Positive.
Let's do this here. So we've got to go through all of the advisements to the jury, and we get that. And right now they're having to go through all the charges. And there was a couple of things. Well, the first question that someone asked, and I want to make sure that I don't miss. Is this jury decided by a majority? Is that how this is going to work, or does it have to be a unanimous decision? Can't hear you.
Oh, I apologize.
Yeah.
Right. So, this isn't a death penalty case. You don't have to have the same kind of, you don't have to have unanimous for this type of case. We've had juries that get locked, and I am betting this is going to be a unanimous verdict that comes out, but it doesn't have to be for a guilty verdict.
Okay. So, in your experience, have you seen like a trial of this magnitude, or someone that's facing 6 life sentences have it get hung in jury? I mean, I think that they were saying the Parkland shooter, like there was like one juror that held out that basically saved that kid.
You only had 2 options with Parkland, so you couldn't say, all right, we can't get him on that, let's give him this. It was either yes or no. It was going to be life in prison no matter what if it wasn't death. And so you had one person locking the jury. Here, you've actually given the jury tools to be able to negotiate. Fine. You don't think he had premeditation. You have all of these other options for charges. He's already admitted doing it. A hung jury is going to be a jury that just can't make up their mind on guilt or innocence. Guilt in this case, a little like Parkland, has already been admitted to. He's not going to skate on all the charges. He's only trying to mitigate the penalty beyond the point of premeditation and first degree. So it'd be very unlikely to have a hung jury.
Do you feel that there is in the first degree intentional homicide? Do you feel like that's a solid stick?
So there were enough people injured and killed. We know that when he went down and started hitting people in the parade, that he wasn't necessarily there because of the parade, right? He had been running from police. And so premeditation doesn't take a lot. If at some point there, when he realized he started hitting people, or he saw the parade and he's like, if you believe that he said, screw that, I'm going down, I'm taking everyone with me, that's premeditation. There's not a time period that's required for premeditation. If you think he's driving like crazy, his mind is racing, he's got some mental health things, and he just starts trying to get away, he's not even thinking about the people that are there, that's a heat of the moment. It's going to be very hard for him to find that kind of, to get rid of all premeditation, because he kept going for so long.
Right.
After how many people do you have to hit before you realize you're hitting people and you make an intentional choice to keep going?
Right.
So the first group of the crowd, I might not have meant to hit, but can you really, how far are you stretching the imagination to believe he didn't mean to hit the people at the end?
Right. Absolutely.
I think you're going to find some level of premeditation here. There are a lot of counts. There are a lot of victims. You may actually find a jury that parses them. So they make a diagram or a chart, and they go through and they say, these first people he hit, all right, we can see he's running from police. He's probably not realizing it, but did he choose, like, the car stopped at points, right?
Yeah.
And then he decided to keep going.
Yeah.
It's rational for a jury to say, at that point, he chose to keep going. He thought about it. He'd stopped. He knew he hit people. Yeah. And for the rest of the victims, we find premeditation.
The prosecution did a really good job of saying that with the first officer when he slowed him down and hit the top of the hood of the vehicle, and then he drove through him. Basically, had to step out of the way as he accelerated past him, which debunks his whole theory. When he just did you hear his closing arguments when he was basically blaming the car? He was like, they're not going to tell you this, but the vehicle had a factory recall. And then they already talked about that. They had it investigated. The vehicle had 150,000 miles on it. It wasn't like this thing was possessed and suddenly started driving through the crowd on its own.
No, and no one's going to believe that at some point the vehicle recall just became a problem after he started hitting some people and it just kept going into everyone else.
And somehow he was able to park the car, back it into a spot, and then get out of said vehicle.
No. I mean, what you're probably looking at with jurors is someone who feels sorry for the fact that he represented himself, who thinks, okay, I mean, there are juries that want to split the baby in half, right? Yeah. One of the moments where, all right, we're gonna get him on some of them, but this poor guy, why do we have to give him, this many life sentences? Isn't one enough? He's still not going to get out, and then we're going to seem super fair. You're also going to find jurors that want to get out of there. I hate to say it, everyone's doing their civic duty, but how many days have they been in trial? We've
been sitting down 14 days, not including the jury selection, which they went through.
they're going to want to get out. So some juries will make a deal just to get out of the jury box with the people who are, saying, hey, I'm not quite sure about count 54, line 6. They're going to give him 54, line 6. They're not going to sit there for another 4 days for one small little bit that some guy in the jury is going to say. So
do you think they're worried about it all sticking? Like, are they worried that, do you feel that the jury would be nervous about maybe they only have 2 or 3, first degree intentional homicides with a dangerous weapon? If they're feeling that there's going to only be 3 instead of 6, like, is that a concern, or do you feel the jury might just kind of feel comfortable thinking like, hey, one of them stuck, that's life in prison, that's it, we don't have to worry about from that point on? And you cut out on me again here. I'm not sure what if you're having reception issues on your end.
Answer the following question, yes or no.
Well, while we're listening, guys, while we're waiting for Lou to come back in here,
Count 45. One reading. We the jury.
When she does, we'll bring her back in. But are there any other questions you guys have as we're sitting here? There's things that have been coming up. I've been taking notes. But again, we're at count 45. We've got 70 something to go. So I appreciate you hanging out with us right now as we're talking to attorney at law, Luai, out of Houston, Texas. She's back now, so hopefully we can make her end work for us.
You're getting me on my road home. So I think that as long as they think they're getting him for one life sentence, the jury is going to make a deal. That's a possibility. That's if you have someone like Parkland, like you asked me. Do I think that a jury is going to walk back there and potentially give him everything? And it's possible that you now have a jury that is willing to rake this guy over the coals and is going to give him everything. You're only going to see deal making if you have someone that pities him, or you have some kind of sleeper juror, right? There are people that try to get on juries that will say all the right things because they don't believe in the system and they want to let people free. Right. I mean, this is a free country. Some people lie. I know it's going to be a shock. Right. For Parkland, you very well may have had a juror who lied, who said that they could vote for the death penalty, but thought that they were, doing a greater good and going to save someone's life.
Right. Let me ask you about the jury real fast. The one thing we keep hearing to the point of nauseum is jury nullification, jury nullification. They kept arguing about whether or not he was going to be permitted to let the jury know that they have the right to jury nullification. Could you tell us what that is and kind of give us a little breakdown as to why that was such a big hang up?
So jury nullification, that's terrible, by the way. You don't want to see this. You don't want to have to go back and redo a jury, right?
Okay. Well, what is jury nullification?
So jury nullification, you will very, very rarely see it in this stage of a case, right? That's something that you're going to potentially have someone call sooner rather than later, and absolutely not this late. So, and this is the defendant that's calling for jury nullification, and this is not when so you don't mean the defendant, do you?
Well, I've never heard of jury nullification.
Okay, so this can go either way. So jury nullification means that you, notwithstanding whatever the jury has, it's very, very, very rare, right? Okay. And no judge wants to do this. This is something that's going to be the very last thing that they are willing to do. Okay. But they are going to say that no reasonable jury could have come up with that answer, right? They're going to say that notwithstanding what the jury found, in order to have that kind of finding, you have to have the prosecution or the defendant that's going to say, as a matter of law, the judge can decide this. So that means that there's no reasonable jury that could have found that, and then they can overturn what the jury said. Now, this isn't a death penalty case. This does happen. Judges like to give a jury the case. Our whole system is built on a jury, right? Okay. So even if a judge believes that they know what the answer is, they will very, very rarely take it away from a jury. Rarely. They want the jury to work. But what they will do is, if the jury doesn't do the right thing, they will come back and they will overturn the jury's decision. And they will say that no reasonable jury could have come up with that. I can decide this as a matter of law. That means there's no opinions here. It can only be decided as a matter of law. So if for some reason, I have seen this before where someone found someone guilty and there was no reasonable chance that they could have found someone guilty, you might find a judge that would overturn it. This is really, really rare. I don't think you would really find this. I don't think it's very likely.
Okay. Appreciate you explaining that. So it's basically like the executive order to be able to turn over the findings one way or the other. So the jury is able to say, hey, we just feel like he's a great guy and this shouldn't be happening, and we're going to go ahead and let him run free.
So if the jury said we're going to let him run free and he didn't do it, it's much less likely that a judge is going to find him guilty and overturn a jury innocent verdict than a judge would overturn a guilty verdict.
Gotcha.
Right? Because our whole system is built on the idea that it's better to have 100 guilty people go free than one innocent man go to jail. That's the basis of our whole legal system.
Ooh,
I can't
never heard
tell
that.
you a
That's
case.
pretty heavy.
That's our criminal justice system. That's literally what it's based on. So I don't even know a case personally outside of law books where a judge is going to find someone guilty when a jury found them not guilty. That's very, very rare.
Okay. What are the chances of an appeal in this process?
Oh, there's going to be an appeal.
Okay. How many levels are there to the appeal process? One of the questions they had is, how many courts of appeal are there possible in this, and will it potentially get to the Supreme Court?
So you'd go up to the Supreme Court, criminal for the state. Here in Texas, we have a Supreme Court, a criminal Supreme Court. Okay. And so you'd go all the way to Supreme Court. I'm not licensed outside of Texas, so I can give you that. Whatever the highest level court in his state is for his kind of action, he can go to. If he believes that this involves a question that the Supreme Court has jurisdiction over, then he can petition the Supreme Court to hear his case. It is quite unlikely that the Supreme Court would take his case if it didn't involve a question of the constitutional process, due process, or some other egregious level of wrongdoing by an earlier court.
Okay. Do you see any possibility of an appeal going through of any kind?
That's weird. Usually I would say no completely. Right. There's been a lot of crap in this trial.
Yeah.
I don't think there'd be an appeal that would go through because it wouldn't be an issue that would change the verdict. It wouldn't be, determinative. I would not be surprised if after this trial he finds a lawyer to represent him, probably a lawyer that wants to get some fame and attention and push through some appeals. I don't think they'll be successful.
Yeah. Do you think that is there a waiting period for the appeal? Let me see it. Hold on. Let me check in real fast with where we at.
Sure.
Right now.
Oh, yeah, I did. We did all this.
I'm not sure if they were. I know someone had said they were at 54 a minute ago. 52. Took over on. I'm terrible at getting people's handles right on any of these, but at 6:03. So yeah, just 3 minutes ago they said at 52. So they're standing. I'm assuming
right,
for the
thank
jury.
You. Have a seat. Count 56. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree.
I think he's bored too.
Yeah, he's I think he shot his load basically, so to speak, with his closing argument there. And then so he was, letting them know obviously, hey, anyway, we talked about that. But is there a waiting period before you can ask for an appeal?
It's not a waiting period. It's whether or not the verdict goes directly into action during an appeal, right? So an appeal you have to be specific. You can't just put in papers and go, I appeal.
Right.
I appeal, someone else decide this. You actually have to say something that was wrong with the judgment or something that was wrong with the case. The time it takes to prepare that is the waiting period, right? So he can put in his papers whenever he's able to prepare that. But I don't see that happening quickly unless he has an attorney just ready to file the papers and they have very specific grounds. Right. His appeal is going to need to be perfected.
Right. And that's where he's going to need to find somebody, like you said, that's looking to make a name. Whether or not the appeals go through, it's going to be a high profile case. Do you feel that there's anything that's happening in this case that might be precedent setting, that might change? Like we've heard a lot of talk about Illinois versus Allen. Do you feel like this case might have some things that are happening in it that will become kind of like case law moving forward?
I think that would be dangerous to
Mhm.
become case law. I would hate to see anything that comes from a sovereign citizen sort of argument that comes from the pro se level,
Mhm.
unless you want to go to the point where we should have forced him to have representation.
Right.
That we proceeded with a case where he was clearly incompetent to defend himself,
Sure.
and that we allowed him to continue.
Would he be able to represent himself in the appeal in court?
You can always represent yourself
So
if you're competent.
So if he feels confident right now, he can take whatever. I'm sure he's already got his letters drafted up right now for his appeals, because it seems like he's been basically gearing towards that this entire trial. He's not been trying to beat the jury.
Right.
He knows that that's not going to happen. Once they find him guilty of whatever string of things they're going to find, be it the reckless endangerment, whatever that might be. I think he's focused, I think, entirely right now on just getting into that appeal process. One of the questions someone had was about sentencing. So how does, and walk us through on in a simple format, how sentencing will work and when it will happen. Let's say they come back, the verdict comes in tomorrow. We'll say by, they finish this tonight, they stay a night in the hotel, they deliberate all day tomorrow. Maybe it takes them to the end of the day, and then let's say 5 o'clock hits and you're like, all right, court's about to wrap, but we're going to give you the verdict right now. What are we looking at for sentencing?
So sentencing is not as simple as people think it is. So they're like,
Okay.
oh, okay, they've sentenced him. This is what it is. Every time when I was in the federal court and people were being sentenced, my judge would take out a giant book of offenses, and you have to go through, and there's a point system, right? It's
Right.
a complicated point system.
Well, that's
So-
his felony point, like his personal point system,
Yeah.
right? Like where he's
Yes.
at on the scale, which he
Yeah.
has a lot of. He has an extensive record, but
And there are an extensive list of charges, and the
Right.
jury could come up with a mixed verdict, and a bunch of factors. And you're going to want to have the victims are going to want to speak. They're going to want to weigh in on sentencing. Sentencing is going to be completely separate. They're probably going to set it after you read the verdict. It's probably going to be 2 to 4 weeks later,
okay,
and they're going to take time all during that time. People are going to be cracking the books. They're going to get it open. They're going to go through the charges. They're going to see where his point system, where he stands. And this judge has been very careful and particular. Every time she's needed to think about something or look up something in the law, she's taken a break. This isn't a judge who is flying from the hip. She's
Right.
careful and she's meticulous. And I don't expect that to be any different during the sentencing. She's going to be meticulous. She's going to take her time. She's going to be careful. And I expect her to come up with a fair judgment, a
right.
fair sentence.
So he did put in the request that he wanted the sentencing pushed out, whatever the verdict may be. You said about 2 to 4 weeks. So that's, yeah. So we could be looking at the end of October, maybe moving into the middle of November. Tell us about the victims panel. How does that work?
So they have a right to be able to speak on the impact to them.
Mhm.
You're going to see his family speak. I've seen a number of these. They're quite emotional. We're seeing someone who's basically a jerk, right? Who killed people, who,
Agreed.
at least recklessly endangered them,
Mhm.
and at worst plotted and planned to kill them, a great number of people.
Mhm.
And that impact on his family and his friends or his community, because I'm guessing the guy has some community. I'm guessing he has some family. The impact
Sure.
on them is going to be great as well.
Sure.
The impact on the families who've lost loved ones, who have injured children, who have amputations. It's a very emotional part. Sentencing
Absolutely.
it can be really probably good for victims
Right.
and for families to be able to be heard.
Right.
But it's an important part of the process, and there will only be a range for the judge.
Right.
She's not going to add up all the numbers and get just one number. She's going to be looking at a range, and she will probably be at least partially impacted by the statements that are made,
Right.
and that will impact where she goes on that range of punishment.
Right.
Just because he annoyed her doesn't mean she's giving him the max either.
Sure.
She doesn't seem like that kind of judge.
No, she's, I think, been, and much to the frustration of everybody, myself included, she's been incredibly lenient, and she's been very stalwart when it comes to maintaining the letter of the law and doing what she has to do for checks and balances to make sure that everything is done appropriately. And
repeat count 66.
okay, she's on count 66. So we're getting close. I think they're going to be 78 counts, 77. So we're getting in there. But are they? Do they open the door for all victims? Someone asks over Porta Potty Peeper over on Twitch says, can all of the victims speak, or is there a limit? Are they invited or subpoenaed?
So they're invited. They're not
invited.
subpoenaed. They're not going to force any victims to come in. It's not going to help their case. You
Right.
force someone to come in. This is going to be voluntary. This is going to be part of their process.
Sure.
Can all victims speak? All victims will be allowed the chance to be represented.
Sure.
They will the mom, dad, brother, sister, uncle, grandmother, all of one victim be able to speak? It is unlikely in a case like this that they will.
Okay.
For judicial economy.
Yeah. So if it was like a child, like, the 8-year-old, they would say like, all right, the parents will give them the chance. Maybe a sibling, but it's not going to be cousins and whatnot. But
no,
or,
unless that's all they have. If all they have is a cousin, they're
Sure.
going to have a cousin. You remember in Parkland where they, it's going to be very similar. There were a lot of victims, and you sometimes saw parents. You saw girlfriends speak. That was the interesting one. You could have different people, but you won't find it outweighed by a number of people from one victim.
Sure.
They're going to try to represent all victims who want to have representation.
Yeah, absolutely. And I think that it'd be incredibly cathartic for them to be able to, he's had the right to face his accusers. I think it's good for them and the ones that are strong, feeling strong enough and able enough to stand in front and face their assailant. And the person, we saw witnesses who were testifying to the fact that they had 4 of her children were injured critically and almost fatally, and have facial scarring and things that are going to be with them forever. So I think that was hard to watch. We all, anyone here, we were all in tears. I can't imagine how emotionally gripping the sentencing is going to be. It's not just going to be a celebration. I think that it's going to be a huge amount of catharsis, being able to kind of just go through the purge of what this guy has done. And especially after seeing this case, I can't imagine that there will be, we forgive you, we hope you find peace in prison type thing. It's the way he's been so defiant and denying basically having done it the entire time, regardless of how he's testified from, and even in his original, statements given to the police, my life is over, I'm trying to come to grips with that. Even through all of it, he's still saying,
I'd be surprised
if it was me.
Have one family member that said, I forgive you and I hope you find your peace.
Someone will.
It's really personal, right? And our system isn't perfect. It really isn't. There are a lot of problems. There's discrimination in our system. Those who don't have money are often the people that take the brunt of it. I acknowledge those, but our system does work better than a lot of systems. And this part of victim impact is important because whatever the victims have to say, even if it's I forgive you, they have the opportunity to be able to say that. They have an opportunity to have their opinion be said to the judge. And I would not discount the part it plays in healing to be part of the process with him now, regardless of what their opinions are. I don't judge victims, right? I'm not going to say, no, you should still stay mad at someone. Whatever their feelings are, they have earned the right to say them.
Right. Do you feel, is there, someone asked about civil charges being brought up?
Huge. He's going to get sued, but does he have money?
Of course not.
So,
but that's going to bring him back to court. However many times that'll be happening, right?
I don't think for judicial economy again, and the fact that there's a limited pool of resources. So one of the things they do in court is if there's a limited pool of money and there are a lot of people that are going for the same pool, they will try to pull them into the same case so that they can be fair. It's not going to be a first person to turn in the child support gets the money, right? It's going to be, we're going to pull everyone in. The guy has $50,000 and this is how we're going to distribute it. And we're going to bring every person in together. Right. I don't even think it's worth it to sue this guy. Maybe civilly, but you're going to be paying an attorney $300 to $500 an hour in order to get a judgment that you can't collect on. If it makes you feel better, sure. I just don't think this guy is going to have enough money to make it worth it.
Yeah. So what about any moving forward though? He's made it clear that he's the theatrics here, and I see where we're going with some of the questions. We're done for the TV. Like when the tornado touched down, the one thing he was worried about was the electronics being messed up that would help the court case be televised.
Right.
I mean, he's been in such a grandiose fashion. I really feel like he's just wondering who's going to play him in the Lifetime movie, you know, and his book that he's going to write, you know, the persecuted Darrell Brooks, whatever it's going to be. They could go after proceeds from anything like that, right? Anything that might go to. Okay, so.
But they have a statute of limitations, so they could choose to do that. But remember, we don't like to have people who commit crimes benefit from their crimes, right? Do you remember OJ?
That's what they were talking about, was OJ.
Yeah. Same thing
That's
with
exactly
OJ.
what they're referring to, was OJ's books
the only
cost
one.
proceeds.
Well, maybe we can see that then, and they can get a judgment. I don't know if the families are going to want to go through that. And I don't recommend anyone buy this guy's book. I would never say his name again. I wouldn't support any show he is ever on after this. This is for the victims. If you want to do something for the victims, then this guy will go off to obscurity. I would hate to see him write a book and commercialize on this.
When you retire to the jury room,
well, I think they finalized the charges and the guilty not guilty for each.
Vote is entitled to
I'm going to turn her back up. If you want to hang out with us, yeah. I know that I keep catching on the fly, so
you do. You catch me on the fly.
An
an attorney's job is never done. I swear we work too many hours. I'd be happy to come back again, but I love your show. Have a great day, guys.
Record of this trial.
You're amazing. Thank you for joining here.
Communicate with the court only by a written note.
All right.
So if you have questions, the court will talk with the parties.
Email me any questions you might have. We can always bring her back on. We can talk some more. She's incredibly informative and definitely knows her stuff.
You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration.
Here we go. We're moving into the final hour. The final hour of Darrell Brooks here in front of the mountains. Interesting. There's some questions that I was curious about. I know some of you were, so I'm glad that we were able to have the Y on here and talk a little bit about what's going on. So it's 6:21 Central right now.
So we have placed each one of your numbers in the tumbler.
Now they're going to go for random jury
numbers. Those numbers will be the alternates.
Alternates, yeah.
Who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I am pulling out is 10. The second number I am pulling out is 30. And the third number
he's going to object to the number
out is 1.
I object to the number 1.
I want to confirm.
It's
But I
prejudicial.
still have 12. I know Madam Clerk did it, but I will also do that to be sure.
So they do this in random, like literally like names in a hat, basically. They have a tumbler that they use, like a thing of bingo. They run the numbers through a bingo roller and pop one out, B52 type thing. Ooh, Christine Seeley, your birthday is 10/30. And at one point, that was your first birthday. Just saying. What's going on? What's going on with that? Oh, yeah, Christine, happy early birthday. And happy Halloween.
And I just confirmed that the other 12 numbers were in there.
I don't think he's glaring. I think he's just got resting asshole face. That's just, Darrell Brooks' look.
Goes back in and then
Either that or this. Feel sorry for me, please.
we'll need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it.
Says Jeriton rises up. That is not my name. I don't consent to being called by that number. Right? that's about where Darrell Brooks be like, no, we want him or her or them because you don't want to be proper. It's not just
Court
guys,
cause,
as
one
he
on
did
each one of
earlier.
them, just in case you're needed.
But yeah. Man, this guy. So these alternates are in case someone gets sick or has a family
Do
emergency.
you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk. will
Raging
keep a
jagoff.
record of who you all are. It will take us a moment just to have all the.
So the jury is
finalized,
now going to be sequestered because they're going into
paperwork
deliberation.
to go back with
I believe they were told to
Jury.
pack an overnight bag.
all of the verdict forms, if I want to get that to Jen.
So they're just responsible for keeping the jury, like they got to corral them, make sure they don't Pauly Shore it in jury duty. Big shout out, Pauly Shore. That's my dude.
All right, here are
Yeah.
the jury instructions as well. The record is 6:24.
Nicole, I got you. Yeah.
All rise for the jury as they're excused to begin their deliberations.
Just drowned myself right there. So this is it. If you're guilty, please stand up. You hit it, Rabbit.
Yeah, I'm gonna need all of them. And then I'll
Yeah,
take
no, I
them
know.
down and
But
highlight
those are
those.
the-
Yeah.
It's all, this is it. Like, just like a tissue, my life is in your hands, as Darrell Brooks once said. Poetry, simple and pure.
Is that closed?
No.
All right, thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They
At
will be in a
least.
separate jury deliberation room, and will only be called upon if needed, of course, after consultation with the parties.
Jits, you're making it hard for people
As
to.
far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else
Fully
parties would
sequestered.
want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep.
Here we go. Of course.
So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
Nope. Eat his dinner.
It is shower day for my pod. We only get 2 shower days
I
a
don't,
week.
so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then, and then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure
Yeah, you
I'm not stepping on their toes since they're in charge of all of that.
Transport this.
but it's
I'm on that.
possible that we get a request for exhibits.
Yeah.
Some
Tough shit.
exhibits
You don't get a
initially
shower,
I wouldn't be surprised if we got that. So let me do this. Let me
Kinda
confer
sketch,
with
that
the
last sip of
sheriff's
coffee.
department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well. Okay,
And one more thing.
go ahead.
I was curious. 61
Here we go.
charges for the reckless. 61 injured parties did not testify. So how does that work? How
They don't have to testify, dude.
essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
You dropped the ball in
I'm
the end
sorry?
zone, buddy.
I got a point though.
No, you don't have a point. She understands the
I'm
point.
not going to comment on that, sir. Of course, the state bears the burden of proof.
Look at that
And they
face.
have to convince a jury
Screenshot
beyond a
that, please.
reasonable doubt.
Pretty please.
For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the
Oh,
close
you
of the
might have just got
evidence regarding any legal arguments you may have had regarding those issues. And so at this point,
Yeah, talk to your attorney.
the jury has the case and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because it's essentially you can't. If no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no
What about the people you
motion
murdered?
in front of me based in law or fact. So for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today. So that the parties are advised of that, but I will do that. Let me confer with the sheriff's department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the sheriff's department and have a more definitive answer for you shortly. Okay.
Can I get my filings?
You want the originals back.
His face,
If
man. I
Madam
just
Clerk
want
can
to
scan them all in and they're uploaded. I don't have an issue
hug
giving
him.
you
and
the
keep
originals
hugging
back.
him.
They will
hug
have the
him.
date stamp. They don't have a time because they were filed in court.
Yeah, that dude looks like he wants to take him up to a ski slope
So you're getting the 2 copies.
and bury him.
So you'll have that. Okay.
See, I didn't interrupt you. See,
I'm sorry.
I said, see, I didn't interrupt you.
Thank you. I appreciate that.
You get no friends here,
Unless
fool.
I would like the parties back in about a half an hour. Thank you. Unless they have a
Mhm.
question sooner.
Rabbit, you are not wrong.
Your Honor, do I have to go in that holding cell or do I got to get to go?
Or do I get? What do you get? What are you hoping to have? That's my questions of curiosity right now are what is his what is he hoping for? You know? What is he really hoping for? Yeah, Darrell Brooks. So the jury is underway, you guys. Man, this could be for a long night. Well, all these nights have been long. What I believe we're going to have to do is just keep it running, and there's no way the jury's coming back tonight. They're going to deliberate for a while. They have a lot to go through. There's no way they're going to be able to make these, make the findings that they need to make before the day's over. Basically, we're going to be in a position where they're going to be going through the process. They're going to eat dinner, then they're going to go to a hotel, or to a large bus parked out back, whatever they have them set up to sleep in. Then they will reconvene in the morning for more jury deliberation. And I guess the judge said that it's going to be at least 30 minutes. They want to eat dinner. And so I think everyone here kind of feels the same way. Like, it wouldn't be a matter of deliberation; it'd just be a matter of filling out the paperwork. Yeah, like, all right, cool. We have to sign. What do we have to fill out to go ahead and just say guilty? But as of right now, I'm not exactly certain. That's Darrell. That's funny. I'm not exactly certain how it's going to work out tonight. They have to keep it open for jury deliberation. So I don't know if there's a cutoff for this scenario where they can say, hey, it's 8 o'clock, we're done for the day, whether you guys are or not. The judge will be back here in just a little bit, and then we'll be able to, I'm sure she'll give a little bit more clarification. Between now and then, though, why don't we enjoy our some Darrell Brooks moments here in the wild world that is this raging hemorrhoid. I'd challenge anyone to smell hemorrhoid. It is not an easy one to throw down. I had to ask Siri about it. I'm not gonna lie. Whatever. But my questions are, like, how do you feel it went? Do you feel like these charges are all going to slide, or do you feel like they're going to be? Do you feel like they're going to hit him with everything? Let me see. I'm surprised they didn't address the jury with, number one, nullification, and two, the recall malfunction drop. I'm not sure what that is, but yeah. So jury nullification, as was explained by Resist Tyrants, is if there's a juror, was it a juror, or if the jury just says flat out, like, we're not going to convict, we're not going to do it, no matter how blazingly obvious the evidence is, we're just not going to convict. We just can't do it. Maybe they have something that is pre-existing. I don't know what would keep somebody in this situation from not convicting, but he was basically making it clear that that you don't have to convict me if you don't want to. Jury nullification, you can just say he's not a bad guy, you know what I mean? The whole jury. Okay, so the jury can just agree that we're not going to convict him because we don't feel like you guys have done enough to prove any of these charges, so we're going to nullify this whole situation. Resist Tyrants, thank you. In which case, as I said, our attorney friend from Houston, it would be really hard pressed for a judge to overturn that. Where a judge can, if there is a situation where that happens, go ahead and veto the jury's decision. And in a situation where the jury comes back, I don't think it would happen. But according to her, we only need the majority because this isn't a death penalty. So they only need a majority vote for the charges to stick. So if that's the case in this one, I feel like, based off the polls and based off everything that we've seen, and my personal feelings, obviously, there's, it's like a 99, 98, 96, I think is the lowest poll that I've seen that's been definite guilty, or, there's been a couple that have been like, either not guilty or there's a chance for a mistrial, things of that nature. But there's always going to be that one there could be that one holdout juror that just doesn't want to, make that choice. I think that's what happened in the Rittenhouse trial. I took a couple days. I think there was like one or two jurors that were just kind of, they were standing their ground for a while. Apparently, this really only comes into play for victimless crimes, weed, prostitution. That would be if for the prostitute themselves. Well, unfortunately, in this case, in this situation, Darrell Brooks was using a 15-year-old as a prostitute, which was his ex-girlfriend, Erica Patterson, got her pregnant. And yeah, it's terrible. Yeah, Nicole, I'll definitely be covering this tomorrow. I'm here till the end. I'm going to run this to the bitter end. So yeah, it's just wild to me that, it took us a lot of winding roads to get to where we're at with this case. Let's I'm going to take a look at, I'm sure we've got a good selection of highlights. This is just Darrell Brooks, man, being Darrell Brooks, and see where that takes us. To me, thank you. Those are perfect Darrell Brooks photos. The fact that he made objections during closing arguments was really not, it's expected for this guy, right? But nonetheless off-putting, let me see here. Dark faces, lesser charges after killing pedestrian. This is interesting. Okay, so let's take a look at this. This is a driver while we're waiting for the judge to come back here. This is in okay. Well, it says a gunshot can be heard from a mile away under the right conditions, an ear-piercing 160 plus decibels for certain handguns. That's louder than a jackhammer or ambulance with its siren at a full blast. It's even louder than a jet engine during takeoff or any concert you've been to. That's a sound heard near the intersection of Teotonia Avenue and Ruby Avenue the morning of September 7th in Milwaukee. When the Milwaukee Police's Shot Spotter, a technology developed to identify the sound of gunshots, heard a sound akin to gunfire that morning, but no trigger was pulled. The sound was Jackie Rourke being hit by a driver as she crossed the street at 5:46 a.m. She was pronounced dead 17 minutes later, 118 feet from where she was hit. And this apparently, the driver faces lesser charge after killing a pedestrian. And this is kind of appropriate because we're talking about Darrell Brooks right now and the execution of a crime using a deadly weapon, which would be the vehicle that he was driving. So I want to take a look at that real quick. So I'm going to keep tabs on where the court's at, so don't worry, we're not going to disappear from that one. And here we go.
Same day, another man also accused of killing someone with his car is due back in court. But unlike Silva, who is charged with second-degree reckless homicide, this other case has much different charges. For Project Drive Safer, the I-Team discovered 741 reckless driving cases since the beginning of 2021.
That's pretty wild. 741 reckless driving cases, 99% fines with no jail time. Now, if you look at Darrell Brooks's charges, again, we're talking about not reckless driving. This is reckless endangerment, so maybe not even worth looking at. But 61 counts of recklessly endangering safety. Reckless driving would be in that category, but in that, who knows if there's a parallel in this. But yeah, 99% fines with no jail time. So.
But 99% of those cases result in fines with no jail time. So how does the district attorney's office decide the charges? As the I-Team's Sean Gallagher explains, it all comes down to proof.
It was at this intersection near Titonia and Ruby where Jackie Rourke lost her life in September. The impact of the car that hit her was so loud, it set off a shot spotter alert. That's the gun detection system the police department uses. The man responsible was not charged with reckless driving, and right now, he's walking free.
She wanted to be an architect and interior design, and she didn't get a chance to do that.
Heather Pistafka is still trying to wrap her head around how her daughter is no longer here. On September 7th, she had an inkling something was wrong when she saw a news report.
A driver hit and killed a woman crossing the street this
that
morning.
an unidentified woman was hit by a car and killed. So she called the medical examiner.
I say, oh, my daughter is deceased, and she said yes. So I haven't been the same ever since this, and I was wondering who took her life.
The man police say was responsible is Kriston Gordon. He stayed on scene and was arrested. But what he's charged with is what's troubling for Heather. The charge is knowingly operating a motor vehicle without a valid license causing death. The court set a cash bail of $2,500, which he posted and was released.
I don't want sympathy, but I just can't. I can't believe that he can kill somebody, and he's free.
Do you wish that he had, heavier charges against him?
Well, I thought they were going to get him for murder.
At this point, he is being charged with the felony for driving in the first place.
That's Kent Lovern, the Chief Deputy District Attorney for Milwaukee County. Since Gordon didn't have a valid license, he wasn't legally allowed to drive. But the criminal complaint doesn't describe Gordon's driving as the problem. Gordon claims there was another driver being reckless in front of him. And as he tried to pass, he says that car bumped his, though police did not find evidence of this on his car. That's when he says he entered the intersection, hitting and killing Rourke.
There's no question that the victim in this case is a totally innocent person, and it's an unspeakable tragedy for her family. But the reality is all of our matters are based on the evidence we have.
The I-Team obtained the search warrant from this crash, where the investigating officer noted, in over 12 years being assigned to the crash reconstruction unit, he is not aware of another instance where a pedestrian being struck activated the shot spotter system.
They could identify her only by her fingerprints.
According to investigators, Rourke's body traveled 118 feet from where she was hit by the car, nearly half a football field. The search warrant says the physical evidence on scene does not show Gordon's vehicle was following the 30-mile-per-hour posted speed limit, but there's no proof of that.
We don't know how fast that vehicle was going at the time of impact.
The autopsy report says Rourke had severe injuries to her head, broken arms, a fractured pelvis, and both legs were broken below the knee. Yet Gordon does not face any charges related to how he was driving.
This person's being held accountable to the extent we can at this point in time, and if additional evidence is gathered that warrants further charges, that will be considered.
Lovern says it comes down to what they can prove, and right now, he says they have a third party who says they saw the vehicle Gordon mentioned.
The police are still engaging in whether there's any other evidence that would indicate that, frankly, this individual was driving actually in a reckless fashion of his own volition, or was he doing something to avoid someone else who was driving in an even more reckless fashion? And that's what we're still trying to learn in this case. Our job is to evaluate the evidence we have and make a fair and consistent decision based on that evidence.
None of this is what Heather wants to hear, as she learns how to get through life without her only daughter.
I can't think about this guy. He murdered my child. And I guess that's okay. So I have to live with that.
Heather tells me she feels like the city of Milwaukee and the court system has failed her family, but she's trying to move past this and just figure out a way to bury her daughter's remains. Now, the man responsible, if found guilty, could face up to 6 years in prison and a fine up to $10,000. He's due back in court on November 11th. Reporting for the I-Team, I'm Sean Gallagher.
Well, Project
That's terrible. I mean, they say that I heard it said once that if you ever were planning on taking someone's life, do it with a car, because you're more likely to get away with it than if you do it with any other type of weapon. What's wild is that's what you're seeing. I'm looking at Law and Crime right now. They're not. I don't think they're back yet. But I will take a look here real quick and make sure we're not missing that on the other channel. Okay. No, they're not back yet. We're good. Nope. Okay, so who's back? No one's back. Witchy 12. Man. Yeah. So the jury. Let me see. The worker that got fired for not getting their job. Now we were hired back there. Yeah. So, yeah, I'm just looking at some of these Darrell Brooks clips. You guys saw his opening statement. You know, he pulled the comparison, the parallel between his opening statement and his closing argument were, I mean, damn near the same. You know, he just had the same, you know, the same nonsense. But this was just yesterday. This was, you know, anytime they ask if Darrell Brooks if he has any other requests or if he has any objections, yeah, well, we all know how that's going to go. That being said, you know, he's definitely going to object. So let me go ahead and pull this one up for you. And
related to the jury instructions, sir.
Yeah, I got requests. It ain't like they're gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
It's funny that she even points that out.
I've been disrespected since the beginning of this whole process. So welcome to the club.
I do. You're right.
Mr. Brooks, do you have any requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
I'm in Kenosha.
How you gonna sit up here and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him. And I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
What a child, man. This was yesterday. You guys can't believe it. Like, this is the same guy.
I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice.
He did.
My final question to you, do you have any requests as it relates to the jury instructions?
I just told you. Am I muted?
No.
No. The judge is really.
I just told you.
Piffy.
I don't know how many times I can't hear everything you say.
Then you should put the headphones on.
Don't you understand? What about that? Don't you understand? Did you see headphones? You can see
You heard that.
You can see boxes. Did you see headphones?
Have you asked for headphones to be provided, sir?
I should have to ask for them.
To enter the headphones.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated.
I'm so manic.
You sit up here and do everything you're doing, and think God don't see what you're doing.
Do you think God don't see what you're doing?
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to
You
the
need
jury
Jesus.
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image sir. That was all this sir and all this. I'm gonna get where I'm going.
Yeah, straight to prison.
Trying to put on this little act like you so worried about what's going on with
It's funny that he says that. She is not worried.
Never did.
She's just a nice lady.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpers when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the
He
same
brought
charge that
this
I'm
double
already
jeopardy
charged?
thing was like a joke. It's hilarious.
You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice.
Oh, I gotta get that.
I'm already charged with the same count
Same count.
in Milwaukee. For the same case. It's the same bail jumping charge. So how am
You
I
obviously
gonna-
learn your lesson.
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in
Oh man.
jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out?
No.
You always want me to not interrupt you, but you always find a
No.
way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it.
These arguments that he has are just.
That I've already been charged with. That is double jeopardy. You can't charge.
I love that he's telling her.
for the
Let
same
me tell you
exact
what double
bail
jeopardy
jumping that I'm
is.
already charged with. That I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Yeah, that's 100% why you're on trial. You know, you guys, I'm going to play this again. If you didn't watch it, my conscience is clear. Actually, I'm gonna put up his closing argument. I think that's what we're here for. I think that it's important that if I'm gonna try to grab a clip of his closing argument here, or just his closing argument, because it just blows my mind. He blamed. I'm not gonna say he blamed, but it's amazing that he actually mentioned that the DA. He said the DA. The real tragedy is the victims here. The victims. And no one's talking about them. The DA isn't doing that. Shame on them for not talking about the victims. And I'm not laughing at the victims. I'm laughing at the audacity of this guy to think you made them victims. You're the assailant. You get that, right? Like you get that. You're the one that you killed and assaulted those people. And then he came back with the fact that it's tragic that we're not paying more attention to them. And what he's just walking right past that. No, we're focusing on penalizing the person who did it to him. And he really, well, here, we'll watch it. It's just really, I'm just going to say it. It's a real classy closing argument. I think he did it in 2-part. So let's take a look at his closing arguments here. Man. It's not just a book; it's the book. He said when he corrected the judge about the Bible. Reading a book, it's not a book; it's the book. Man, that blew my mind. All right, so here we go. Let's closing arguments. So this was closing, and you're right. He looks just like the elf from Bad Santa. Like Just like the oath.
Because I'm going to inform the jury of their power. They deserve to know.
Jury nullification. Which good, great, you did. Good job. Did nothing. I'm sure that they could have Googled that or, whatever. At any point in time, you didn't do anything spectacular.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties.
After he's been warned, do not mention jury nullification.
You and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
So
frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike misstatement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal.
Like, it blows my mind the angle he takes on this.
That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun.
Just saying. You hit it on the head. He does look just like the elf from Bad Santa. Proceed.
Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year,
Okay, the judge is back in here, so we're going to go ahead and
from the clerk of court that she had received an email that the person sending the email had found a post on Justice for Darrell on Reddit. So it's a subreddit. I'm not familiar with how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And
come on.
I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case. And here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those Justice, the number 4, and Darrell, all no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine. And if, of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be
Thank you,
the
man.
judge that will further be reviewing it in terms of any requests related to that
I'm reading
investigation.
it right now.
I will simply be handling whether any requests as relates to this case in particular.
I don't know about the subreddit. I'm reading the Reddit itself.
Hope
The
we have the copies for
says
it.
this is abuse of power. I'm not saying he's innocent. Just saying that
Provide
it's
those. Go
completely
ahead.
unfair and he's being mistreated.
Making sure you was.
Go ahead.
His trial's railroading. If I was in the jury, I wouldn't be able to
What
find him
is
guilty.
this?
He's excited.
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value and return for value these documents. I'm confused.
At this point, sir, I'm providing
He
the
feels like
information.
it's some kind of Hail Mary.
I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have.
It says, I am a member
And
of
I
the
will
jury
add
on
this,
this case.
I
Here are my
will,
thoughts on the
of
trial.
course, it's important that the
On the
results of
subreddit.
any investigation be turned over to the parties.
Okay,
I'll
I'll share this with you guys here.
But
I got you.
that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this?
This is it's total bullshit. There's no way.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of
This
court was
is
received
from
at
October
9:10
24th.
a.m.
From yesterday.
And then that email and the attachment, I'm aware of a second, I'm aware of a second email that was sent to our clerk of court at 10:02
Let's do this for you.
10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system. And I simply said, obviously, that information needs to go to law enforcement. I haven't seen it, haven't reviewed it. But any person who works in the clerk of court's office who has received an email that email about this topic will be forwarded to the Sheriff's Department. Their forensic unit is handling the investigation, to my understanding. Attorney Hopper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings.
Right.
In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not
I got
true.
you right here. I'm going to pull it up for you guys right now.
Exhibits any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this
Yeah,
case.
so I've got it pulled up on screen for you guys right now.
Is largely critical
It's
of
on
the
reddit.com.
court and to some extent the prosecution, but
While she's talking, I'll just say, I'm a member of the jury on this case. Here are my thoughts on the trial.
Mr. Brooks, that's why it's under a
on this subreddit
called Justice for Darrell.
Yeah.
And I don't believe there's any reasonable reading of this.
Yeah, I'll put the link in here too.
Lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Okay. What am I doing here?
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it. I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light. I will say just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. There's no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Well, I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court.
Yeah, okay.
So with that, the courtroom, go ahead. I'm sorry. Something else, Attorney Hopper?
A different topic, Your Honor.
Oh, sure. Go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked.
All right, I'm going to go ahead and bring in just the
Well, I'm willing to discuss that.
tech team is on it. Yeah.
Yeah.
I put the link in the comments to the Reddit,
I
the
would
subreddit.
object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble, because we do have the technology.
In the comments is how that subreddit starts.
But that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about a video. We have the ability to play it directly. There's a TV. I should have said that. Probably not to you. Why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time. But as far as other exhibits,
so it would be only the exhibits that's been
received.
So
Correct.
nothing new, nothing's gonna come out of the blue and be like, yo, yeah, we're gonna.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you.
It's funny, it says that in this, it says, I am not Darrell Brooks. And then someone's like in the chat is like, well, yeah, he doesn't have access to the internet. You can get on TikTok right now and look at videos of prison, of people in prison, like filming themselves cooking. And
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
For example, they may come back and say, we'd like to see exhibit 15, which is the map, the large map of the parade route. Okay. They might want to see the other map. Maybe they want to look at a video. There's a lot of exhibits, so I'm not going to speculate what they want.
Yeah.
Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
Rule on it.
All right, fair enough. Anything else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but
chain of custody.
what was the time limit that the court
subject matter jurisdiction
wanted to work off of for giving notice to the parties when the verdict?
Links are in the
30 to 60
chat.
minutes.
Okay. Thank you.
So that will depend on when it is, if it's late in the evening versus during the day. And you might be wondering, how late will I let that we're done for the evening. They'll come back in. I'll read them the instruction about they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go again where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay, thank you.
You're welcome. Anything else from you, sir?
Did you talk to the jail, the deputies?
I did. Thank you for that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later. If that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're gonna stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been
Then I will
told
have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction. Boom!
You knew I was about to say that.
Sir, I'm not gonna address it, I already have.
He's having a
There
good
are
old time. I don't
requests
get
for
it.
free exhibit.
This dude's a nutball, man.
Is that his number? And he signed up, but I do.
Good fellas, you're right. The judge is a very nubile individual. She's a very attractive individual. Had so many guys commenting like, man, I wouldn't mind dragging out the trial if I had this Judge Darrell.
I'm not gonna say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was gonna go one by one. So I'll start with exhibit 15, which is the map. What's your position on that, sir?
My position is at this point, what is the relevancy of the map? I think it's been seen a million times. I know it by heart now. That's probably the only one I know by heart.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send exhibit 15 back to the jury room. It is an exhibit. And there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So I don't even it's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well, there is an amended information, and I clearly instructed the jury on 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
$15 seconds.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck. We could put it up if you want to preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to, we'll verify that the technology is working, and then I would play it for them twice through. And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me. All right, your response, sir?
Yeah, I don't object to it. Keep this in order. I guess my objection would be it would be hard to say why the jury would request it. I'll just let you rule on it. I don't particularly. So many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why we need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any reason why it needs to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then. I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say, stop. And then can you go back and can we watch it again? Because that's my experience. So I'm really trying to avoid that. So we'll stay out here. And then we'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits and then make sure the technology is working. So if the state wants to have that ready to go.
I set for value and return for value these documents, Your Honor.
Thank you. Do you have, you know how to do that, right? We've done that before.
It's one button.
generating for me to turn on. Is there audio with this, or is it just video?
Just video.
Okay, thank you.
I think it's safe to say that I don't feel like the jury is going to make a decision. I know we all feel like it should be a quick and easy jury deliberation, but I feel pretty confident that the jury is going to be it's going to take them a little bit longer than just an hour or two to deliberate on all the charges that they're having to deal with. And they're having to deal with all of the charges right now. It's not just the one or two. They have to figure it all out. Yeah.
You can turn it off.
Oh shit. I'm sorry.
Is it off?
Dog hit his
All
head.
right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the
Well,
entire.
I'm here right now,
investigation
you
in the
guys.
hands of the
Texas
sheriff.
Patriot. This dog of mine, man, he bumped the sorry, he bumped the modem or the router, one of the two, and yeah, I'm here in I'm in Wisconsin. I'm very close to Waukesha. I got my people in Waukesha that I'm actually trying to meet up with right now.
All right, I'm gonna step off. Obviously, the courtroom remains open. And we'll let you know if there are any additional questions. Procedures.
Subject matter jurisdiction, Your Honor.
I decline
Will
to
we-
address that, sir.
Will we be addressing it for the record?
All right, so the jury, okay, again, jury deliberation. Let's touch on this for a brief moment, shall we? The jury is going to be deliberating probably for quite some time. Yeah, man. You guys, I appreciate everything, man. Like I said, like we were talking about the stars and joking around, but like the legit, like, you know, contributions go towards to help make this all run towards keeping the stream alive, and also you know, feeding my pup, all those things, you know, keeping the internet on, all that action. Yeah, anyway. Yeah, this guy is definitely cocky, definitely feeling good. He's feeling good. Like, I mean, I'm sure he's probably just as happy that the trial is, you know, the trial portion is over. But I don't think it's because he feels like he's won anything. I think he just hopefully has accepted the fact that he's cooked and he's not going anywhere. He's going to spend the rest of his life in jail, or locked up. And that's just how it's going to be. The judge, I had to step away for 2 seconds, so I didn't catch that. I was handling my dog issue here. What they were just handling. If anyone wants to catch me up here real quick, or I can just pop back, take me 2 minutes to you know, dial that in. But yeah, he's not on the stage anymore. Yeah, he's just he's basically like a support actor at this point. He's not like the main star of the show, and you know, he's just Darrell Brooks in it at this point, you know. Either way, so we're waiting on the jury to come back, and until that happens, we're kind of just in a holding pattern, honestly. We're going to give you this one, the box for it. I like the box for it one. This one right here. This is Darrell Brooks in his box fort, or his fort house. Instead of it's just funny instead of courthouse. But okay.
Different speeds. Is that in the question?
They just said, can we see exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate, but I think it's proper given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record. Not allowed to answer any questions I ask. From your name,
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
of course it's denied. Of course, because you can't prove it on record. Come on now. Has yet to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
I would love to hear a song and see you dance. All right, sounds like the jury, it sounds like, is getting ready to come back in. So they might just say we're done for the night. I said probably around 8 o'clock. That's just too spot on, really. I can do this all night. No, I can't. I don't want to. This guy.
Yay, nay?
The video clip is now ended with the state just confirmed the speed at which it was just played.
Yes, 40%, Your Honor.
Thank you. All right, and if there's another question, the court's going to step off. Obviously, will remain open.
I thought the jury was coming back in, but I was mistaken. So while we're waiting for the jury to come back, we can watch a little more of his closing arguments, which he went from blaming the car to scolding the DA for not focusing on the victims enough. Just the most, man. This guy has done the most. Yeah, it just blows my mind. Yeah, let me. What I might do is another one of those split screens, just so we can keep an eye on the. Yeah, we'll do this just for a couple minutes. And what I'm doing is kind of just a studio split here, so we can keep an eye on what's live, and then we can also take a look at Darrell Brooks's closing argument here, which is borderline comical. Everything about him is just a clown show. I mean, it's just one, almost like one big running joke almost. So here we go. Okay, we'll stop that one. Here we go. I'm getting decent at this. Well, guys, it's been a long day. I mean, we've been in chair. I mean, what are we at? 4 hours in, 8 hours in. So 12 hours today is what we've been in the stream this for 12 hours today. And yeah, it feels every bit the 12 hours. So this is more of what we were watching earlier. Darrell Brooks's closing arguments is part one here. So
I've sat and gone through this. Feeling so powerless. Letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to.
Apparently, I'm being told that the stream is frozen. I'm not exactly sure how that is because I'm seeing it. Okay. They're saying Facebook is having issues. I don't know what the story is on that. It looks like YouTube is doing just fine. Okay, so if it's on Facebook's side, I don't know what's going on with Facebook. But on YouTube, we're golden. So, yeah, if you guys are having issues watching it, I'm questioning, is it Facebook altogether, or are we having issues with just Facebook here? Well, you know, this is the perfect time for it to have issues, I guess, because it's okay. Well, yeah. Let us let's figure it out, shall we? Give you all you guys on YouTube will give you something to look at while we figure out this Facebook situation.
And I'm sure that the prosecution will beg to differ, but the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact.
There we go. Blame it on the recall.
Misstatement of the facts, facts not in evidence.
Was in fact recalled. Was in fact a class action lawsuit against Ford for those model vehicles.
Sustained, the jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection. That is.
It's information. It's information.
Hold on. Go ahead.
Statements by.
Sorry for the interruption.
Facts not in evidence, Your Honor.
Chris Reed, thank you very much, man. Appreciate that.
Sustained.
How's it a misstatement when I have?
I'm not sure what's going on with Facebook. YouTube's doing just fine.
This is information that I feel like you needed to know. You should have known.
Mm-hmm.
Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
I'll tell you what I'm going to do, guys, because Facebook is acting up. What I'm going to do is just close out of here and then come back in. It's a Facebook. CJ, other lives are doing the same thing on Facebook. It's a Facebook issue. Oh, okay.
The defendant has an utter disregard for human life. utter disregard. for
Okay,
human life.
so if it's Facebook, then I'm not gonna flip out about it much.
Not realizing that
Um,
they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life.
yeah, it would appear that it's a Facebook thing. I'm seeing it on other channels as well. So
They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? Because I'm going to inform the jury of their power. They deserve to know.
yeah, we're having issues on Facebook. But if you're still here, that means that you're not on Facebook because Facebook is clutched and out. So we got our Twitch and our YouTube folks in here. Super cool. Appreciate that. Y'all are my squad as well. So what I'm going to do here is I'm going to, because apparently Facebook is cooked at the moment. Yeah, apparently Darrell Brooks shut down DB. I blame DB. Darrell Brooks, yeah, a big douchebag. He broke the internet. He broke Facebook. So what are you gonna do? What I will do for you is pull this up right now so we know that something's happening somewhere. You know, but the jury's out deliberating at the moment. So, man, I think I got that. So jury deliberation has started, as it says here. I'm going to try to give you guys while the internet is broken, let's go ahead and do this for you. Closing arguments, here we go. All right. There we go. Yeah, we'll do this one for you guys. I'll keep tabs on the situation with the jury, whether or not they are coming back or not. But I'm going to give you guys the second half of that of his closing arguments here, which are hilarious. I can't help but laugh, honestly, because he's such a ridiculous asshat that it's borderline comical. You know, like the things he said. Well, you'll hear it. If you weren't here for his jury for the closing arguments, man, you guys are in for the second half of a real treat, if you will.
DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this
Okay.
Yes, correct. How long are each?
It's crazy that Facebook is just down like that.
Exhibit 3 is 4 minutes and 14 seconds. And exhibit 4
6 minutes or so.
is 6 minutes and 58 seconds.
7 minutes.
Okay. My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
Noted for the record. Any specific reason, sir?
It's my menopause. I love you and I
Your
hate you,
evidence,
Barry.
sir?
Chris Reed again. Thank you very
The
much.
jury's requested to look at them, so
Man.
I will be playing them for
Yeah,
them.
we'll play more of
do
his closing.
Exhibit 3 first, and then Exhibit 4 shortly thereafter.
But I'm not sure. It could be Facebook, anything. Darrell
Be
Brooks.
addressing subject matter jurisdiction on the record.
I doubt it because the jury's sequestered. So
No, I will not.
Is that a judicial determination, Your Honor?
I can't, oh, you're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
The arrow in the middle of.
Oh, we can get rid of that, clear annotation.
Is that a tacit agreement, Your Honor?
Go ahead and play Exhibit 3 in its entirety. There you go. You had that one, right? Yeah, I got it. You can stop that one. They're asking it to be stopped. Any objection from the state?
No.
From the defense?
No.
Okay. All right, switch to Exhibit 4. Any objection to stopping that video?
No.
All right, Mr. Brooks?
No.
All right, it'll be stopped.
Judge, for the record, this one was stopped at 1:38. Do you know what time we stopped it on Exhibit 3?
35 seconds, I think.
Thank you.
Sure.
Thank you, Madam Clerk.
Yeah, Facebook in general is just having issues.
I would think you might want to stay close by.
Was that a good way to reach the state?
I'm not sure
Yeah.
you did.
We all know it was a BS post. Good that they're making the record clear. CJ, can you verify that? Everything I've seen, I went ahead and I looked at the post. I pulled it up and I looked at it. It was in the comments. I posted a link for you guys in the comments. It looks fraudulent as hell. It looks, yeah, it does look, it's super suspect. It's not one that I give any bearing to. For the Reddit post, yeah, they try to say that there was some photo verification. It's nonsense, man. Reddit, it's a clown show. Why is it a black screen? I don't know. Facebook everywhere is down, so I'm not sure. Yeah, it says something went wrong. I cannot watch a live stream. Damn Facebook. Yeah. Okay. Well, if you're over on Facebook, if we in the mods, if you can go ahead and put the link in for YouTube, I'd appreciate it. Let's bring everybody over to YouTube, and we'll go that route. Yeah. So we're waiting on the jury right now. So I'm going to post a link here. Anyone else want to do the same? That would be great. And let's oh man, I tell you guys what, I'm feeling it, man. I'm feeling it. You know, at that point, let me see. I'm going to share this out too. Copy that. And here we go. And paste. It looks like Facebook's back up. Okay, we're getting a couple people back in on Facebook. But this is the YouTube link just in case you guys are not able to connect on Facebook. Facebook has to shut down to put a lot of people in Facebook jail. Okay. Well, I mean, I don't know what the Facebook jail is going to be all about, but you know, it's Facebook jail. You know, good old Facebook. Yeah, I'm checking out other streamers as well, and they're all saying the same thing. Yeah, that was weird. It looks like it's still having issues on Facebook for me.
The jury would like to be done for the evening and come back tomorrow. So I said they should assemble. We'll get.
Okay, so the jury's about to come back in.
They're sequestered.
Yep, Facebook's gone again. You guys come over to YouTube if you're on Facebook. If you guys would put comments in mods, if you guys would please put comments over in Facebook. That we'll go ahead and do that actually right now. Okay.
Like to break for the day. I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room. So I'll read a modified kind of version of instruction 50. We are in the record.
Subject matter jurisdiction.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Hold on.
And we are live right now, yes. Apparently the jury is about to come back in, and then they should be doing their thing. The jury will come back, and then they'll be released for the night. They said that they're done. They'll come back first thing in the morning to keep deliberating, and it's just a waiting game.
The other alternates, they're in a different place. So you have to get every.
Yes, we do need.
But I'm glad everyone's over here from YouTube. Set up notifications.
2 people that got excused from the jury.
3. There were 15.
Yeah, if you guys would set up notifications over here, that way if this happens again, you'll know that YouTube will be here.
Well, you did say 2.
This is live, Jeremy.
You said one had got excused before, and then another one was getting excused.
No, I only excused 1. We've had 15 since.
He's going to push for a mistrial because he had terrible representation.
What happened to that second one that had the COVID scare? What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to get
Yep,
feelings.
Facebook
It's been a
crashed.
long day. I'm tired too.
I would agree. But I'm not,
I don't know. I think 3 jurors. I think he said they replaced 3 jurors.
I just thought you said 2. You said 2.
They had 3 alternates. Maybe 3 people just said they don't want to be a part of the case anymore. That could have been what happened, and they just said, "Hey, I'm done, and I'm out of here." Put me in my box for it. Yeah, thank you, Penny Purdue. You guys that are over here on YouTube, we got a handful more viewers over here. Appreciate that. Oh man, what a long day, you guys. Tip of the hat to anybody who's been with it, for any of you that's been with us, but it has been a long day. We are, like I said, creeping up on. I've been running stream today for 13 hours about. So it's one of those days. I thought it would take hours. Darn, love it. They're not done deliberating yet. They're just going to be done for the night. Yeah. No, Penny, I got some talent. Bella Fist, thank you for becoming a new member over on YouTube. You guys jump in on YouTube, become a member over there. We're going to be doing a lot of things over there. The super stickers, you guys are amazing. Mo, thank you so much for that.
Thank you, everyone. Please be seated. The record to reflect, I have the 12 jurors who have been deliberating, plus the 3
Paula, way to be.
Who were sequestered in a different jury room.
Yeah, I want
to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications.
You guys are amazing.
Do not use any electronic devices such as a mobile phone or computer.
And thank you guys for becoming members over on YouTube to join in the Paradox, which is what my YouTube crew is called.
Or your experience as a juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example,
That's a good one on pain
do
meds,
not
Kayla.
communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should
I
report
think
that
Jit's
to
teeth
me.
are floating right now. He's got to get outside.
I know you're
and
not
use the
going
bathroom.
home. You're going to
Charles, man,
another
thank you so much.
location, but do not discuss this case among yourselves with any other juror until you are back in the jury deliberation room tomorrow. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are all excused for the evening. We'll see you back here tomorrow at 8:30 a.m. All rise for the jury.
Look at him smiling, giving the happy face. Did he cry? Oh, he cried. Teresa Berry. Yeah, he cried. He cried. Stay off Reddit. Yeah. Oh, man. So, jury is done deliberating for the day. They were excused. They ate dinner. They're sequestered. Their phones, electronics have all been taken away from them.
All right. Thank you, everyone. We are in recess. We'll see everyone tomorrow morning at 8:30. 8:30 a.m. I trust that the jail will give you a shower. So whether that's tonight or tomorrow morning before you come back to court. But I will order that.
8:30?
Yeah, but that's what happens.
That's when we start court every morning, sir.
No, it haven't been.
Good. Fuck this guy, man. Everything about him I want to punch. Just 100% square in the freaking coccyx. They get plenty of that later, though. You guys, it's been an incredibly long day. I'm fully bushed and tired and over. Kayla, hey, speedy recovery. I'm wishing you the best, and I know you just had a surgery, so yeah, definitely get feeling better. Yeah, I'm gonna wrap it. So it's been a long day. Tomorrow at 8:30, guys. Yeah, we're gonna be back in doing what we do, and I'm not sure what's going on with Facebook. So if you're on YouTube now, make sure to set up notifications, like, subscribe, and make sure that when you hit the bell, I think you have to go ahead and click on the little bubbles and go to all posts. So you make sure you get all the posts, obviously, in case for whatever reason one slides through the cracks. We don't want that because we want to make sure that this raging asshat, we get a lot of opportunity to watch what happens to him in the coming days as the jury has to do what they have to do, which is find justice, right? Justice for Darrell, apparently. But you guys have an amazing night. Thank you so much for tuning in and for the super chats, the super stickers. The stars are there today on YouTube or on Facebook. And I will definitely see you guys bright and early tomorrow morning. Just give you one of these real fast for.
Pardon me? That was before the
Don't get brazen with me.
And just in case.
You need Jesus.
Boom, you need Jesus. See y'all in the morning. Take care.